happy to take any questions.
Good, I got a question.
Okay.
Our website has, on the bottom of every page, has copyright 2009, I think it was 2009, I'm not sure if it's updated. There's a date, it says copyright with a copyright seal at the bottom of every page. Does that protect everything on that page or that website? When if we have, for example, like 10 or 12 articles that I've written, do they have to have that same wording each time? Or is one time on the website on each page sufficient?
One time on the website on each page is great and is sufficient. It couldn't hurt to put it on a specific article that's valuable, especially, let's say if the article is in a PDF format and it could be downloaded separately and emailed or saved and read later, then you really want to make sure it's separately on there. A blog post, like I have it both on my blog at the bottom of the screen and also at the end of every important post, I put a separate copyright notice. You really can't, it can't hurt to put more rather than less.
What I've got is...
But what you have is sufficient, I guess.
So when you have blogs, how do you copyright the whole thing? What makes it so that you can put that on every single blog or on every single page? How do you do that? Is it that you're copyrighting the website, or?
So from a notice perspective, what you want to do is put it in the template of the blog somewhere, so it appears, you know, somewhere on the top or the side or the bottom, and every time somebody views it, it'll show up. Then when you have actual posts that are significant and creative and important, make sure you put a separate notice at the bottom of that post. In terms of registering it, it's not as easy to register something that's always changing like that, like a newspaper or a magazine. What you can do is pick a few examples of what's the most important content and register those. You can't, I mean, it doesn't make sense practically and financially to file a new registration every time you update the blog.
So you just do a general basic and then everything else.
Same thing with the website. Like if your website has a lot of creative content, I advise my clients once a year to file. And you know, and then if they do a major overhaul, sure, let's file it then when the new version comes out. But otherwise, once every year or two is going to be sufficient, as long as you're placing that proper notice everywhere along the way.
So I have to place the notice without filing it?
Right. The notice, you don't need a for copyright, you don't need a registration to use the notice. Anybody can use the notice anytime.
I got another question, but I want to... Go ahead.
When you set up an LLC, obviously you have to verify the name is available. But that only covers you in the state, that doesn't cover you nationally, is that right?
Correct. That doesn't cover you nationally. And the search that the state does is very, very limited. So if you were trying to set up XYZ LLC, the state wouldn't notice a conflict generally if there was an X-Y-Z LLC. They're only searching exact matches, when in reality, X-Y-Z sounds the same, means the same, you know, almost looks the same, and could be a real conflict. So you really need to go beyond that and search the web and search the USPTO. You can pay companies or attorneys to do a really full-blown search that can come even with an analysis from an attorney. That's the safest way to do it. But at least do what you can to search elsewhere. And also because 20 years ago, a printing shop located in Falls Church may not have had a lot of customers outside of Northern Virginia. And so if there was another printing shop in California with the same name, the odds of them ever bumping heads would have been really, really minimal. But today, they probably both have websites. They're both competing for the same names, the same domain names, and the same Facebook names, and the same Twitter names. And also, if I'm looking online for the cheapest printing services or the best printing services, I could send my files to California and they can ship it to me. It's just as it's almost just as easy as using the local print shop. So that's also, you know, really changed the game in terms of just searching within your state.
So you trademark the name to protect it, is that what you do?
Right, you trademark the brand name to protect it. The LLC name is often overlaps with the brand name. It may be your brand name, but it doesn't have to be. Your company could be XYZ LLC, doing business as Jim's Auto Body. They don't have to be the same name. Some companies have a lot of different brand names. Our law firm has 3 or 4 trademarks because we have a website, we have a blog, we have a new iPhone application, and they all have different names, so we have a multitude of brand names. And many businesses have a multitude of brand names.
What questions? I have one. There's common law marriage. Okay? Is there common law intellectual property? In other words, if somebody in this room simply didn't do it, they've been in business for 12 years or 22 years, and suddenly somebody challenges them, would it be, in the eyes of the law, still their trademark if they've been using it for 18 or 20 or 25 years? Is there common law?
There are common law intellectual property rights for trademark and for copyright. They're not as strong as the registered rights, but they do help, and so it's never too late to enhance that or to fix that. Another benefit to registering it is once it's registered, you're going to show up in that U.S. Patent and Trademark Office database. So some new company in Alaska that's doing a search thinking about a new name, hopefully they're looking online, and if they see that that you're a direct conflict, it's eliminating a conflict before it even has a potential to arise.
The fact you've been using it for 10 or 20 years could help you.
Absolutely. In a dispute, a lot of it comes down to who was using it first.
What you're saying is avoid the dispute.
Question back there? Was there one?
Two actually. Where do you draw the threshold between copyright on issue and then taking the extra step to register? And two, dealing with trademarks, once a trademark is registered, do you have to use the little logo, or is that just to let other people? Are you protected without using?
You are protected without it. You don't have to use it, but you really should use it at least sometimes in some prominent ways. I know stylistically or whatever, some people prefer not to use it because it's cleaner, but if you're not putting people on notice that it's a registered trademark, you may not be getting all of the benefits of having that registration. So it is advisable that you at least use it sometimes. That could be on your letterhead or business cards or one place on your website. It doesn't have to be every place that you use it. To address your first question, what I advise is that you pick a few of the most valuable types of content and intellectual property you have and make sure those are protected and perhaps registered. It may not be practical to register all of them. So if it's an issue type situation, pick the ones that really best represent what you do or best represent the creative content that you produce and make sure those are protected to the maximum. You follow up?
Well, one more on the trademark item. Pizza Hut trademark. I think we all know what that logo looks like with the little hut and the script.
They changed it recently.
As a trademark item, is it just that visual that we're looking at, or is it, Pizza Hut is without a logo, just in all caps or something?
A great question. Okay. Pizza Hut has 3 trademarks off the bat that I can tell you. One, just the words Pizza Hut in any font or color or anything. 2 would be their logo in Pizza Hut in red writing and whatever else their logo looks like. And 3 is where trademarks can get really creative. Pizza Hut buildings don't look like other buildings, right? They have a special roof design that looks like the hut that matched their logo. That could actually be a trademark, the shape of the building. Because if I am driving quickly by somewhere and I see that red roof, I know that that's a Pizza Hut. And so it identifies their brand and it's a trademark. So text, logos, slogans, and then even creative things like the shape of that Pizza Hut building, like the shape of a Coca-Cola bottle is a trademark, like the chimes for NBC, which I won't embarrass myself by trying to say, but everybody knows when they hear a commercial for Law and Order or whatever, what those chimes sound like. That's a registered trademark, just the sound.